Welcome to Lessons from the Sensei, Law, Business, and Life.
Hello, everyone, and welcome back to Lessons from the Sensei, Law, Business, and Life with Denis Quintana, veteran Orlando defense attorney. I'm Sean O'Connor, and today Dennis and I are talking about how bail really works in Florida and why some people don't get out. A lot of people assume bail is simple. You pay, you go home, but that's not how it works for everyone. And sometimes people walk into court expecting to leave and don't. So let's break down what's actually going on when it comes to bail and why it doesn't always play out the way people think. Hi, Dennis. How are you?
Great, man. How you doing, Sean?
I am doing A-okay. Yeah, the bail's in the news a lot over the last few years with bail reform, and I know it varies by state, I think, anyway. But myself included, before I started talking to a lot of attorneys, people think bail just means you pay and go home. But how does it work in real life in Florida, in your experience?
So bail. I mean, it's a very good question because everybody's familiar with bail, and a lot of people are familiar with bounty hunters, right? I mean, there used to be a show about
Yeah, I was going
bailsmen.
to say, wasn't there a show called Bounty Hunter or something?
Exactly. And so what bail is when somebody's charged with a crime, they're supposed to come back. So cop arrests me, I go to jail. I don't need to sit in jail until the whole process is done, but they want to make sure that if I get out of jail, I'm not gonna, just take off. And so bail it's kind of like a collateral, kind of like a
Hmm.
marker, to make sure that you come back. And so bail is, I don't know if you guys have Aldi in Florida. We have Aldi grocery stores.
Yeah, I know
And
what you're talking
if
about.
you Okay, if you go to Aldi grocery stores, their shopping carts have a little quarter,
Oh, yeah,
right?
yeah.
You got to put that quarter in to get the cart, right? And the purpose
Yeah,
of
yeah.
that
So you're getting
quarter is
you're
to
getting the card out. You're getting the card out on bail, and then when you bring the card back, you get your bail money back.
that's it, right? The purpose of that quarter is just to make sure that you bring the cart back so they're not chasing the carts all around the parking lot or people are walking out
Yeah,
of the parking lot taking them home, right? So bail is the same kind of thing. It's a collateral to make sure you come back. Now, here's the issue with bail. Bail is commensurate with the level of offense, right?
ah,
So let's say I get arrested for trespassing. That's a low level misdemeanor offense. They might release me on my own recognizance where I don't have to pay bail, because the likelihood of me going to jail, right, for trespassing is very, very, very nominal. Okay.
yeah,
But let's say I commit armed robbery with a firearm. Now, I've used a gun, and it's a,
yeah,
a crime of violence. That's a first degree felony. That's a very serious offense, and the likelihood of me going to jail if I'm guilty is very high. And
yeah.
so, when the likelihood of me going to jail is very high, what the court hears is, well, the likelihood of you running is
Oh,
also very high,
right. You
right?
might have more. You might have
Trespass,
incentive. Yeah, you'd have incentive to
exactly.
leave town.
So what
Got it.
do? They raise the bail amount, right? When you have a serious felony, bail can be very high. And
Yeah.
bail isn't just monetary. So, for example, they might set a bail, but they also might say, hey, man, you need to surrender your passport, right? We don't want you skipping the country.
Traveling.
Or
Yeah.
we need to put you on a GPS monitoring. Or we also sometimes have these conditions of bail. Let's say I'm arrested for domestic violence, right? I'm accused of beating up a girlfriend. And so
Yeah.
they're going to say, okay, well, you're entitled to bail, but as a further condition, you're not allowed to have any
You.
contact
Yeah.
with her,
You
right?
can't go
Uh,
over
you
there. Yeah.
you can't go over there. Well, there's cases pending. So
Yeah. Yeah.
bail is what are going to be the pre-trial conditions of release that will A, ensure that you come back, and B, that will make sure that the process is fair. So here's another
Hmm.
example. If I'm arrested in a conspiracy to traffic in cocaine, right? Conspiracy by definition means there's more than one person arrested. Means I'm acting in concert with one or more others to do something illegal. And so often in a conspiracy case, the judge will say, okay, let's say your bond is set at $100,000. but you're not to have any contact with any of the other co-defendants during the pendency of this trial, right? So you guys aren't supposed to collude together or threaten each other or, conspire
I
any
get it. Right.
further as to how this is going to go. So bail is very, very, very tricky and very important,
Yeah.
right? Because what we're
Yeah.
fighting
Yeah.
about is your liberty. And remember
Yeah.
that at the point of bail, you're presumed innocent,
Right.
right? You've just been accused. So the law says
Right.
you're presumed innocent. So nevertheless, right, there are restrictions because, if I get arrested for DUI, they don't want to just say, okay, Dennis, you're drunk. We're going to arrest you. As soon as you get to the jail, just pay $500 and you can get back on the road, right? So they're going to go, all right, man, listen, we're going to arrest you, but you've got to spend the night in jail. So there's a
Yeah.
cooling off period for DUI, right? You got to at
Mm-hmm.
least spend, the night, 24 hours. And same thing with domestic violence, right?
Ah.
They accuse me of
Yeah.
beating my girlfriend. They don't want me to just pay $500, get out and go back and murder her, right? So
Yeah.
pretrial release has different conditions. In domestic violence and DUI, there's a cooling off period. In other cases, there are conditions of release,
Mm-hmm.
and in some cases, you're not entitled to bail.
What determines whether someone like walks out on bail or has to stay in? Is it a severity of just the severity of the crime?
Generally, it's going to be the severity of the crime, but sometimes, here's an example where it's not the severity of the crime. Let's say I'm already on probation, right? I got arrested last year for DUI, and I was placed on probation for 1 year, right? It's now 5 months into my probation, and I get arrested this time for theft. Okay, I go to Walmart and I steal something at
Yeah.
Walmart. Okay, the fact that I'm on probation and have now committed a new offense,
Another.
right?
Mm.
A DUI is a misdemeanor, a first time misdemeanor, if it's a first time DUI, and a petty theft, a small theft, is also a misdemeanor. So they're generally things you could bond out on. But because I
But
was on
together.
probation,
Yeah.
now, right? So think about probation in a job. Hey, Sean, we like you. You've got lots of talent. We're
Yeah.
going to give you the job on a 90-day probation. Okay,
Right.
Sean, as long as you show up, you do your job on the 91st day, everything's good. You got a full-time job. But on the 14th day, if Sean doesn't come to work or Sean leaves early, or you don't do what you're being trained to do, right? Then you don't get the job on the 91st day. In fact, you might not even make it to 90 because you're on
Right. Right. I was
probation.
gonna say.
They
Yeah.
revoke your probation. So if I'm on probation for a DUI and I go steal something at Walmart and I get arrested, when I show up in court for a bond, they're going to say, Dennis, you're eligible for a bond on the petty theft, but we're revoking your bond on the DUI. You didn't finish your probation. Now you have what's called
Right.
a violation of probation. Because when you step back, right,
Yeah. It's
going
like a
back to
third
that
crime.
DUI, it's a prior crime, but the difference is the judge sentenced you to probation instead of jail, right? So I'm not putting
Right.
you in jail this time. I'm going to give you probation. You may have to do things like community service, pay a fine, do some driving
Sure.
school. Great. But if you don't pay the fine, if you don't do the driving school, you don't do the community service, or if you commit a new crime, that's a violation of your probation. Now you got to come back, and you come back to the same judge that sentenced you on the DUI. And so now the
Right.
judge can do whatever he or she wanted to do the first time or could have done the first time. So that's an instance where you're not entitled to bond. The other
Got it.
instance is what you were alluding to. What about the level of the offense? So again, trespassing, I may not even have to post bond, right? Low level
Right.
offense. DUI, if it's a first time offense, I'll have a cooling off period, but I'll get a bond. But what about first degree murder? Okay,
Mm.
I walk up to somebody in the plain day and intentionally
Yeah.
put a gun to their head and kill them. Well, the judge might say, you know what, that's premeditated murder. You're a danger to the community, and so
Yeah.
we're not going to release you. So there are some crimes that you're just not entitled to bail, and generally they are crimes that are A, very serious, and B, where there's you know there's a saying, it says, the proof is evident and the presumption of guilt is great, right? So it's a serious crime. Somebody died, you were seen with a gun and you put the gun to their head and they were alive before you fired the gun and they weren't after you fired the gun. So the proof of
Right.
evidence is great and the presumption of guilt, right, is
Is.
also
Yeah.
great. It's self-evident and great. So in cases like that, you may not be entitled to a bond.
Got it. Where do people get caught off guard, when and they realize, oh, they're not getting out like they expected? I mean, I think that murder example is obviously extreme, but are there places where be like, wait, I thought I'd be getting out of here, but they're not for some reason.
In two circumstances. And so the first one is, yeah, listen, I'm going to bond out, but the judge at arraignment said I have $1 million bond, right? And I'm like, crap, where's my family going to get $1 million, or how am I going to qualify for underwriting through a bonding company for them to post $1 million bond? So if the bond is too high, I may not be able to afford it. And
Hmm.
so I thought I was going to get out, but I'm not going to get out. I'm going to have to do something else, either figure out how to get some money, some collateral, or come back and petition the court to have a bond reduction hearing because
Yeah.
I'm not able to afford a bond. So the judge has to give you a bond. The judge is supposed to give you a reasonable bond. And a
Right.
reasonable bond is one that is supposed to balance the interest of the government, but also the interest of the accused. And so, if they give most people $1 million bond, they're just not going to be able to afford it. And so it
Yeah.
has to
The
be
same as the
reasonable.
same as no bond at all or no bail at all. Right.
That's exactly right. That's
Yeah.
exactly right. And so, but here's the other circumstance that it's come up more prevalent, right? In the past couple of years now, I'm getting a lot of people that are eligible for a bond, but because of an immigration status, they have an
Uh,
immigration detainer. And so they might have gotten arrested for driving without a license, right? Normally you'd get a $500 bond for driving with no valid license. But if there's an immigration detainer, then you're not getting out. Even if you post the bond, you're not getting out. And so that's not the criminal aspect of it, that's the immigration aspect of it.
right.
But that's where people get stuck. They're like, "Oh man, I thought I was going to bond out and now I got an immigration hold on me and I can't get out because of immigration."
Right. Oh, got it. Yeah, yeah. What about having a lawyer involved? What kind of difference does that make at this stage? So are there avenues to get around or to you know deal with this?
Absolutely. Because remember, we're talking about the judge is trying to balance the interest of justice to make sure that you show up, but also to make sure that you're not overwhelmed or have undue restrictions on you while you're presumed innocent. And so when you have a lawyer, you've, whether you know it or not, you've manifested to the court, "Hey, I'm going to defend myself," and B, now I'm responsible for that court date. When I take a case and I file my notice of appearance with the judge,
Right.
the judge says, "Hey, Dennis, all these court dates you're responsible for." Now, I can waive the appearance of my client. So when I show up, it complies with the client's obligation to show up. It complies with their conditions of bond. But I can waive the appearance so my client doesn't have to show up. And I do that as often as I can, right? As a courtesy to them, right? To not waste their time. But it also manifests that there is a second method of control because the clerk is now sending notices to the bonding company and to me. And the judge is looking to me. If my client skips town, the judge is like, "Where the hell's your client? Didn't you have
Yeah.
contact with him? You're supposed to have him here." Right. So I'm not a bounty hunter, right? I'm a lawyer, so I'm not required to physically bring them to court. But let me dovetail into that bounty part because when we talked about the bounty hunter, so when
Yeah.
you go to post a bond, right? Let's say you have $100,000 bond, you can have $100,000 and post it with the jail, or you can go through a bonding company. And a bonding company is kind of like an insurance company. They'll front you the money. They'll post a marker, a pay to, $100,000 commitment to the jail in the event you don't show up. But they will charge you to do that. So they'll charge you 10%. The statute requires them to charge no more than 10%. So if I have a $100,000 bond and I don't have $100,000 or I don't want to post $100,000, I go to the bonding company. They will post a marker, a pay to, a promissory note, and they'll charge me $10,000 for that. Now, what happens is if I don't show up for court, that's when the county is going to take the $100,000. So they're going to collect on that promissory note from the bondsman. But now the
Yeah.
bondsman's going to go, dude, you gave me 10 and you just cost me 100. So now the bondsman turns into a bounty hunter. And the
Oh,
way
yeah.
they get their $100,000 back is by putting you back in jail, right? If you skip bond, the bondsman, they've got a limited amount of time, but the only way they get their money back is if they go and arrest you and put you in jail.
And
So
then
that's how the bondsman's
the
your
county
best friend when you're
refunds the
getting
money.
out. But if you want to skip, bondsman is your bounty hunter.
Yeah, interesting. What about, I mean, you talked about parole violations. I'm wondering, in other ways, does someone's past, prior charges, history, does that start to affect what might happen, or is the past the past? And
No, look, with respect to criminal records they're not admissible as to the issue of guilt in any particular case. So, like we were talking about, about the
right,
rules and how you have to play by the rules. I can't go to court and go, man, this he's a dirtbag. He's been arrested 14 times, so I'm sure he's guilty this time. That's inadmissible. But where a prior record does matter is at the pretrial level. A judge can look at your pretrial, your past criminal record in determining conditions of release. If they see that you failed to appear before, that's something they can take into consideration. If they also see that you have an extensive criminal record, even though this offense might be a petty theft, the fact that you've got 2 murders on your record means that you have a bad criminal record, and any new offense could subject you to going to prison. So that could be another reason to raise a bond amount. But the most likely place that a criminal record comes into play is at sentencing, right? If you're going to have some kind of negotiated plea, or you're going to have a trial and the jury finds you guilty, that's when the court considers your prior record. And so obviously the longer your record, the more serious the offense is, then the worse it gets for you in terms of sentencing.
yeah, that makes sense. The we've seen that in the movies, and like, well, based on your priors.
Yeah, so it's not just whimsical, right? So years ago, the legislature in Florida, they came upon a circumstance where in Miami in the 80s, lots of marijuana was being smuggled in on these cigarette boats, and people would get caught, with hundreds of pounds of marijuana, and it was happening every day. And the judges were like, "All right, it's a $500 bond. All right, $500 bond." But if I got arrested smoking pot in Jacksonville, right, in the 70s or early 80s, they might put me in jail,
Right.
right? And so the legislature said, wait a minute, it's the same state and it's the same law, but people are being treated differently, right? And so that's not fair. So what they did was they said, let's have some sentencing guidelines. Let's try to give the judges a sort of a poll star, a range, a metric. And so they came up with this complicated system, the Criminal Sentencing Punishment Code. And what it does is it takes each different criminal offense and it assigns it a numeric value. By assigning it a numeric value, they're trying to create an objective basis in order to start plugging in this formula to give
Right.
judges a range. So, based on the level of the offense, it's going to score X amount of points. And in Florida, once you get over a threshold number of points, right? Once your criminal score sheet passes a
Is
number, that
Yeah.
number happens to be 28. But the way they get to 28 is each offense has a number of points, and then you
Right.
add up all those points, and then you subtract 12, and then if you get to 28 or more, each point over 28 is a month in prison, right? And so
Okay.
what that does is and it's not just that simple. They also have, you subtract the numbers, but then you have to give the judge a range, 75 up to 125. 75% of that number
All
or
right, you lost me.
125.
You lost me. Forget
Yeah,
it.
so here's what happens basically. Let's say the number of your criminal sentencing score sheet comes to 32, right? Well, the judge can sentence you down to 75% of 32 months or 125% of 32 months, right? But that's just a range to give judges a guideline so
Sure.
the state laws are being enforced
Some
uniformly and the
consistency.
sentences are being delivered uniformly. So
Got it.
why does that matter? Because we're talking about prior record. And so
Yeah.
prior record is scored in a score sheet, just like a new case is scored in a score sheet. So the longer the record, the more points. The more points, the closer you are going to prison. And then more
Got it.
points, the longer you're going to go to prison.
Yeah. It's like, yeah, you want a low score, like golf.
Yeah, man, you don't. Yeah, exactly. Exactly. Like golf.
Hey, we're out of time,
Oh,
but more soon, I'm sure. Great. Thanks for being here.
no, thank you, man. Always a pleasure.
That's it for today's episode of Lessons from the Sensei, Law, Business, and Life. If you'd like to learn more or speak with Denis Quintana, contact Sensei Legal at 407-694-5403. Thanks for listening, and don't forget to leave a review, like the episode, or maybe subscribe so you don't miss a future episode. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.